Good morning, everyone. As you know, I'm Judge Lois Murphy. It's my pleasure to be with you today. This morning, I'm joined by some people you know and some you don't know. Judge McNally was on our program yesterday. Judge McNally's from Dauphin County, right here. Judge Gavin of Berks County, and Rhodia Thomas of Mid-Penn Legal Services. The reason these are our panelists this morning is we're going to do a deeper dive into one of our projects, the Legal Services Organization Pilot Project, which you heard about yesterday, to really talk about how the appointment of counsel, the appointment of trained counsel from a legal services organization manifests in court. What kinds of effects has it had on due process in our courts, and what kind of effect has it had on the outcomes for people who appear in guardianship proceedings before these two judges in these two courts. So here's our topic. As I said, Judge McNally's from Dauphin County, Judge Gavin's from Berks County, and Rhodia Thomas is from Mid-Penn Legal Services. So we talked about this yesterday, and the chief mentioned it this morning. Through the Administration for Community Living, the Office of Elder Justice in the Courts, and the Advisory Council, and the Supreme Court of Pennsylvania received a grant. And one of the demonstration projects that we've implemented is this 4-county legal services project that provided funds for the appointment of legal counsel for all alleged incapacitated persons over age 60 in those counties. The counties are Dauphin, Berks, Cumberland, and Perry. Dauphin was our pioneer. The counsel are appointed in initial hearings and also in review hearings, and are employed by Mid-Penn Legal Counsel, and notably receive training and education and become expert in guardianship proceedings. So here's sort of the money slide, the notable improvements that we can document. Fewer grants of guardianships and plenary guardianships. 32% of cases in this pilot project in the 4 counties resulted in no guardianship. Over the same period, 17% of cases statewide resulted in no guardianship. That includes cases where the petition is withdrawn, cases where a person dies before the hearing, or cases where a less restrictive alternative might be identified, but really noticeable improvement. Increased use of limited guardianships, 28% in the 4 counties compared to 4% statewide, and decreased granting of plenary guardianships. Again, only 40% of cases in these 4 counties with the Legal Services Project granted a plenary guardianship. So less than half are granting plenary guardianships in both capacities, compared to 79% statewide. So really cutting that in half. Very dramatic improvements. So I told our panelists this is going to be a discussion, and everybody has their microphones. And I just wanted to talk to people about what's from your point of view, what did you see in court that changed due process in your courtroom, each of you, and Rhodia, from your perspective, because of the appointment of counsel through this legal services project?
Well, I can tell you that we were the county that was identified, and I want to thank Judge Paula Ott, who cornered me at Justice investiture and said, "McNally, you do guardianships, right?" "Yeah." "Well, how would you like to do a pilot program?" I said, "Okay," and we talked about it. So I've made this analogy before, some of you may have heard it. I felt like Johnny Bravo from the Brady Bunch. I fit the suit. And the suit was the people in Dauphin County, like Mary Catherine Scott, who worked very hard to provide us the good bones that we could have this project. I was quickly told that I played no part in hiring the attorneys. I was kind of told to stay in my lane, that a memorandum of understanding would be entered into between Mid-Penn, the county, and OEHAC. But I was kind enough to have been introduced to one of the candidates who's with us today, Michelle Cluck, who came into chambers and introduced herself as one of the attorneys that would be doing the project. The one thing that I was impressed with very initially was the fact that Michelle actually showed the initiative to reach out to the court, which is really what's very, very important in the legal services organization model, is knowing who the attorneys are. It's ultimately the court's responsibility to appoint counsel who's qualified through training and experience. And sometimes that can be difficult. Each county does things very differently. In Dauphin County, for people under the age of 60, we still have contract attorneys who take on these cases at a fixed rate. It's not a very good rate, but I was introduced to those attorneys. So myself, I didn't know what their training or experience is, which kind of made me a little uneasy because ultimately the buck stops here. I have to appoint counsel who's qualified through training and experience. With the legal services organization model, I know that Michelle Cluck is qualified through training and experience. So the one thing that I think most impressed me that I've seen is Michelle and the attorneys at Mid-Penn have made everybody better, have made everybody work just a little bit harder to get those better outcomes that you just saw. And that is through consistency and accountability. Because quite frankly, Michelle Cluck holds the court accountable, as she does the petitioners. She holds everybody accountable, and she's dogged in her work. The one thing, as I explained yesterday, that I hate to see, that every judge hates to see, is someone that just is going through the motions. And we've seen that too often with court-appointed counsel for a variety of reasons, one of which they're not qualified through training or experience. Secondly, they have other competing interests. The rates that counties typically pay are not very competitive. I'm jealous of Judge Wood Skipper in Philadelphia County with their rate. And quite frankly, if you have that rate, we'd love to transfer some of our cases down to you. So you take that with the legal services model, you take that out of the equation. When you have an attorney who, this is what Michelle does. I know that when I appoint counsel, I know for certain that she's going to satisfy the requirement that she actually meet with her client. At the same time, again, we have attorneys that are on a contract basis that are sometimes meeting their client and their families for the first time in the courtroom. And sometimes their clients don't even show because they haven't contacted and told them that they have the ability to show up. Courts kind of struggle with whose responsibility is it to get the alleged incapacitated person there. That's still on for debate. But I know every time that I appoint Mid-Penn Legal Services that they are qualified by training experience, that they are going to meet with their client and their families, the stakeholders, and that they're going to file that certification. The other thing that I know is Michelle is going to, from the very first discussion, require that the petitioners explore lesser restrictive alternatives. She's going to require, again, that the court make findings with regard to lesser restrictive alternatives. And so when we look at those results, those are not the results because of the court. Those are the results of Mid-Penn Legal Services making sure that everybody works a little bit harder.
Judge Gavin, have you found that since you've had the Legal Services Project, that family members have become identified and involved in cases more than before? Other family members?
Yeah, once or twice. In all seriousness, absolutely. So interestingly enough, the very first case that I did, in the greater scheme of things, I'm relatively new to the bench, and I'm also relatively new to the Orphans Court Division. When I became head of I'm the head of the Orphans Court Division. When I became head, we actually had a new president judge. Our prior president judge had been the head of the Orphans Court Division, and he was the head of the Orphans Court Division because nobody else wanted it, okay? And that is in fairness, that's a systematic problem within our judiciary that we do need to address. So I had a discussion with the new president judge, and I said, okay, what are we doing here? And I said, the other judge who's head of Orphans Court doesn't want it. I mean, he wants to run from it kicking and screaming. And I said, if you want me to, I will do it. And I did. And as I've expressed to Judge Murphy, I probably have maybe 14 years left on the bench, and I'm all in. I understand I am not being replaced. But the first decision that I get as head of the Orphans Court Division is, hey, there's this memorandum of understanding to bring in Mid-Penn Legal Services to handle our cases. And I say to the president judge, I said, okay, I'm new to this. Whose decision is this? And she says, yours. I said, all right. So I said, it's my decision. I'm going to do it for two reasons. Okay, the first reason is practical. The second reason is principled. All right? The practical reason was this. It was somebody else's money. Okay? Berks County taxpayers were not paying for it. Sounded like a reasonable plan to me. But the second was more important. The second was the principled reason. The principled reason that I thought to myself was, we have been giving appointed counsel to people in this country since at least 1963, when the United States Supreme Court decided the case of Gideon versus Wainwright. I'll share with you that in preparation for today, I went back and I looked at that case. And I looked after that case, and I found out some things that are important for us to understand here today. Gideon versus Wainwright was not the first time the Supreme Court had done this. They'd actually done it back in the 1930s. And in a decision in the 1930s, Justice Sutherland said, the right to be heard would be, in many cases, of little avail if it did not comprehend the right to be heard by counsel. In another decision from the 1930s, the United States Supreme Court said the assistance of counsel is one of the safeguards deemed necessary to ensure fundamental human rights and liberty. Fast forward to 1975. And in 1975, in another case from the United States Supreme Court, the case of O'Connor versus Donaldson, it dealt with giving legal counsel to people who are involuntarily committed. And in that case, the United States Supreme Court said, a state cannot constitutionally confine without more a non-dangerous individual who is capable of surviving safely in freedom by himself or with the help of willing and responsible family members or friends. Now, guardianship is a wonderful public policy. It's a very good thing. But as with all things, there are unintended consequences. And I would suggest that over the years, there have been times that people have been effectively confined without due process and without legal counsel. So the fact that we've gotten to this point, it's unfortunate that it took so long. It's incredibly amazing that we're there. So to your question, have we had any? The very first case I had, the very first guardianship case I had, I am brand new to Orphans Court. I don't know anything. And it is an 88-year-old woman in a vegetative state. We appoint Mid-Penn Legal Services. The agency, they had originally said it was an emergency, but when I scheduled the hearing, they were a little too busy for the emergency, so they wanted it rescheduled. And they had said, we can't find anybody. We've looked high, we've looked low, we've looked everywhere. We can't find anybody. I appointed Mid-Penn on Thursday. We had the hearing on Tuesday. And there in the courtroom with Mid-Penn Legal Services was the woman's niece. Might have been a great niece. And she said she didn't want to be the guardian of the state. She didn't want that responsibility, which was fine. But she wanted to be the guardian of the person. And the reason she wanted to be the guardian of the person was she wanted to have, and this is a repeated theme through this, she wanted to give the woman dignity. So to answer your question, Judge Murphy, without question, from the start, from the very first case, Mid-Penn has looked for and found family members. On another one, and this one was more recent, Mid-Penn came in, and it was the day of the hearing. And they said, Judge, sorry, we're not ready to go. I need to ask for a continuance. And I said, why? He says, we've just identified a family member yesterday. And the way they found it was the petitioner in their original petition did not include this family member, but added it in a more recent filing. And the person was from out of state. So I turned to the petitioner and I said, what's your position on this continuance? He said, we object. I said, why? That's my favorite question. Why? We say, why? She said, well, we need to get the financial applications done. And I said, okay, we'll get them done, but it'll get denied. I said, are you kicking her out? She says, no. I said, good, because I wasn't going to let you anyway. And that hearing, we still have to have that hearing yet. But to Mid-Penn's credit, they looked at it. They checked the file. And the petitioner's position was, oh, this person's from out of state. I don't have to list them. I don't care whether you don't have to, you should. And Mid-Penn looked.
Judge.
I've had similar experience with Mid-Penn with Michelle, but the one thing before I was doing guardianships, I was doing children and youth work. And they have something known as the Family Engagement Initiative, which is something that the agency must continue to pursue family until relieved by the court. And they must specifically ask the court to be relieved of that obligation. So I brought that mindset over to my court to ask petitioners what they have done to identify and contact family members, because this is part of a healing process. And what's very, very important to understand is that if we get the family involved, they will thank Mid-Penn and the attorneys for looking out for their loved ones, for re-engaging them. And from the court's perspective, a lot of the problems that we will see down the road in a will contest, in challenges to someone's use of a power of attorney, can be headed off by engaging family at this stage. So I think it's vital that the judges and the attorneys and the petitioners continue to pursue family engagement, because that's a question you're going to be asked by the court.
Rodia, I wanted to get you into the conversation here, and hearing what Judge Gavin shared from case law and the acknowledgement of how important the role of counsel is. And to me, and I hope you'll be able to address this a little bit, having counsel is the first critical step, but counsel has a role and an ability to impact the due process in the courtroom in so many ways, by preparation, by meeting the family, by bringing in facts, by advocating that the person be present, by advocating for assisted listening devices or interpreter services and all of those things. Can you just talk about how having capable, prepared counsel helps improve due process in the way court proceedings proceed?
Is this on? Yeah,
Uh-huh.
absolutely. And thank you for the opportunity to speak this morning. First of all, I want to back up just a little bit about, I was explaining this, I think, to Judge Gavin. We were talking earlier this morning. Periodically, we do needs assessments about what our clients need in the particular counties. And of course, we do housing and protection from abuse and custody. And when we did our last needs assessment in 2022, one of the issues that rose to the top was elder law and elder abuse and financial exploitation. And so we worked several projects in that area, talking to people about wills, powers of attorneys, advanced healthcare directives. And when this project came along, what made it so exciting for us was the fact that this was another layer that we could add onto it, particularly because it was targeted towards those who are 60 and over in our counties. And the counties where they're operational, of course, they're very different. All are made of rural, urban, and suburban areas. And in one county in particular, Berks, is a large Spanish-speaking population. So with our team, what we have always tried to address from the beginning, and I'm glad our advocates are sitting over there, those who are the primary advocates on this project, our team, the training was crucial, number one. Number two, it was zealous advocacy for the clients. And that meant getting to know the individuals. It was meaning, and it may mean that you have to meet with them a couple times or more than a couple times. Different times a day, depending on whatever the issue is. As Judge Gavin and Judge McNally have said, finding family members, but not just finding family members, it's finding the appropriate person, not just anybody. It's finding the appropriate person. And also recognizing where the person is and establishing, maybe they don't need a plenary guardianship. Maybe they just need help with, a caregiver to help them do cook or something, or clean or something like that. But they can manage their own finances and those kinds of things. And it's really getting to know the person. And in that way, I think, when you think about what we're doing here, these proceedings can take away a person's liberty. And we want to make sure that if that is going to happen, and there are going to be people that it's the right person in the right organization, number one. We don't want people in subpar facilities. But also we want to make sure that to the greatest extent possible, the alleged incapacitated person is involved in those decision-making about his or her life, because that's important too. It's about, and I know Judge Gavin said it, and I wasn't here yesterday, but I heard the word dignity, but it is about dignity of the person. And that's what we try to uphold in all of these cases when we are appointed for all of these cases. And I do have to, I think the legal services model works because of that. But number two, I also think as the state looks to expand, I think there's a need for persons less than 60 as well. Because we have a lot of folks who are aging out of, maybe they have been born with a disability or something like that. And they need counsel as well. That's just my own personal opinion about that.
All right, great. Have you, and I'll put this to any of you, have you seen a case where a person was able to do, after counsel was appointed, advanced planning, sign a power of attorney, put something else in place that worked as an effective alternative to guardianship? And how did that work in one or two specific cases?
I have had it happen. I had a case last year, I believe it was, where someone had suffered a traumatic brain injury. And obviously, under those circumstances, there was an emergency petition and eventually a final grant of a guardianship. And then it just kind of languished. And then this person, over the years, because they were relatively young, and when I say relatively young, I'm saying they were right at the cusp of 60 years old, but they had the ability to make decisions because their condition had improved over the years, to the point where when we had a review hearing, which was called sua sponte, because what had happened was we had a guardian monitor report, and the monitor, who's an attorney, said, I don't really know why this person needs a guardianship. So we scheduled a review hearing. And keep in mind that the proponent, the petitioner, always has the burden at these review hearings. They have to establish by clear and convincing evidence that this person is still incapacitated. And when the petitioner presented their expert on cross-examination, their expert just crumbled. And when specifically asked, does this person have lucidity to grant a power of attorney, much to the chagrin of the petitioner, they said, yeah. So under those circumstances, that person was deemed to have the capacity to grant a power of attorney. And eventually what happened was several weeks later, another hearing was held, and the determination of the guardianship occurred in favor of power of attorney. Now, there's good and bad about that, because as Judge Gavin said, guardianships are not all a bad thing. Some of the greatest abuses that we see are when someone is a power of attorney, because who's reviewing that? And I think in one of the questions asked in advance is, who are reviewing our powers of attorney? So the court has to have its antennas up and say, okay, at that follow-up hearing, who is being appointed the power of attorney? Because that's one time that you'll have the eyes and ears on them, because otherwise, like I said, a lot of the biggest abuses that we have are not in guardianship proceedings, but they're in the powers of attorney.
So I'll share the discussion that Judge McNally and I had previously, that you may or may not be aware of this, but he and I are both of Irish descent. So we both have the gift of gab. So just put up with us. You hadn't noticed? Nah, nobody noticed that. So here's mine, and I think this one was particularly interesting. So we got the petition for the guardianship. I appointed mid-pen. We scheduled the hearing. And on the day of the hearing, mid-pen asked to continue the hearing. So which, of course, I said, why? And they said, Judge, it looks like she's getting better. Okay, and that's one of the considerations. What is the likelihood that they will regain capacity? So we gave it some time. I forget how long it was. It wasn't long. It was maybe, 3 to 6 weeks, somewhere in that time frame. And we came back, and sure enough, the medical professionals were saying she had regained capacity, and the prognosis was good. All right? And mid-pen has successfully convinced the petitioner to withdraw their petition. But I had a problem. And I said to mid-pen, I said, all right, but this individual needs you. Are you done if this petition gets dismissed? They said, oh no, we're in. We're going to continue to help this person. And we will get her in, and we will advise her, and we will get her to the point that she can prepare and sign an appropriate power of attorney. So there was a case where, it couldn't have worked out any better.
And that raises an interesting topic that sometimes we get, and every county handles it differently. You know, the Act specifically requires the appointment of counsel, but it really doesn't define the scope, and it doesn't define when counsel can get out of the case. I've had a couple circumstances where counsel has filed simply a precipice to withdraw his counsel. And I said, no. You have to file a petition, a rule to show cause has to be entered, and we actually have to have any objection because, quite frankly, sometimes family members may object to counsel getting out of the case. We've never had that experience with Mid-Penn Legal Services. I've had that experience with private counsel who wants to get out of the case, but all the time, we also know we review files. One of the biggest mistakes I see counsel make is they never withdraw. And when there's a delinquency in a hearing, we schedule a hearing and we notify counsel. I've found out that counsel's dead, counsel no longer practicing law, counsel themselves is a ward and a guardianship. So what's really important for people to understand is make sure that you understand what the court's expectation is. And that's the one thing that Mid-Penn knows. What my expectation is how long that they will hang in the case. They're not as anxious as others, as I'd mentioned, to get out of the case, but my expectation is the counsel is going to remain in the case at the very least until the inventory is filed 90 days later in matters of the estate. Because if there is a problem, chances are it's going to happen when that inventory is filed or not filed. And I know that Mid-Penn Legal Services is counsel of record. They are going to look at that inventory, and if something looks a little weird, they're going to ask questions.
Rodia, did you have anything you particularly wanted to share, or I can ask you another question? Okay. I guess my question is, so how has Mid-Penn been involved after the guardianship proceeding, just as we're talking about, after the initial hearing? What kinds of cases have come up where there have been either review hearings, sale of property, inventories, problems that arose after?
Wow. I'm looking at my staff back there, but I don't know that I'm qualified to answer that.
Okay,
But I
sorry.
do want to. One of the things that I missed stating earlier was that I think with this project, one of the things that it really does, and the judges can challenge me on this, is that I think it builds trust and confidence in the system when we are appointed as counsel, and that they have the and for the alleged incapacitated person, and if family members are involved as well. I think it builds in the court system because oftentimes, particularly when you're talking about folks who are from very either marginalized or vulnerable populations, there may not be a lot of trust in the court system. And I think with the work that we're doing on this project, I think that it serves that dual purpose with the court and with the alleged incapacitated persons and their families, and even, with petitioners in some cases as well.
Yeah. You made me think of something, which is, I haven't had the privilege of having Mid-Penn in my courtroom because I'm in southeastern Pennsylvania. I am working on an RFP to try to get legal services attorneys into my courtroom. We're not there yet. I have a lot of wonderful attorneys that we do appoint. And during the pandemic, actually before the pandemic, I would say, we got video displays in our courtrooms, and I kept trying to encourage attorneys and others to use them, particularly if they were telling me the alleged incapacitated person couldn't travel to court, couldn't come in because of their illness or their hospitalization or whatever. It was really hard to get people to use them. They said, I don't have anybody to run the camera, I don't have anybody at the hospital, we can't do it, Judge. Well, in the pandemic, everybody learned how to do it. And it opened up one thing for me that has transformed our courtroom, which is we also got family members to participate, who, including family members from out of state, were able to participate. Sometimes they come to court now, and sometimes they still ask, if, depending where they're from, if they can participate by Zoom video conferencing. Sometimes the alleged incapacitated person is brought to the courtroom, but if they can't be, or it really wouldn't be in their health interest, we will accommodate doing it by Zoom. So it's just transformed how open our courtroom is, how accessible our courtroom is. And I have a lot more family members participate now. I mean, it used to be we would have a guardianship hearing Tuesday, 10 a.m., whatever time, in a physical courtroom in Norristown, and out of 3 hearings, 1 would have a family member show up. But now we have family members all the time. And I think that also improves confidence in the process and confidence in the judiciary. They know they get an opportunity to be heard. They don't feel like it's happening behind closed doors, and they didn't have access, and they didn't have an opportunity to participate.
Yeah. And I think that what that has fostered also is that those family members that are remote are more willing to step forward and become particularly guardians of the estate if they can do so remotely. We've had some instances where actually we've had the wards, the AIPs, testify remotely, and Michelle Cluck has been with them in their home, meeting them where they are at. And there is nothing that instills more confidence in the family than seeing counsel who will go to those lengths to protect the rights of their loved one.
So, go ahead.
I am going to be the one who disagrees.
Okay.
In fairness, I have mixed feelings about the use of any type of electronic testimony, and allow me to share it with you. I'm going to begin with this, and it's slightly different, but I tried a jury trial about 2 months ago, and I always speak to the jury afterwards, and in that particular case, we had 3 witnesses who testified electronically. And I go down and I talk to the jury, hey, well, how was your experience? Whatever. The first question that was asked of me by a juror was, whose idea was it that witnesses didn't have to show up live anymore? Okay? If you look, we don't have any real guidance on it. The one rule I'm aware of that gives us guidance is it's actually in the family rules of civil procedure, and it basically says for good cause shown, the court can allow somebody to testify electronically. There's only one case under that. It's called Fotopoulos versus Fotopoulos, and the witness was a minor witness in a divorce case who was undergoing chemotherapy at the time. And the court said, yeah, that's good cause. Now, I'll share with you, just last week, I got a request for somebody to conduct a hearing virtually because it was inconvenient to drive, okay? And Judge McNally said yesterday, court is not intended to be convenient, and I completely agree with him. Could you imagine Justice Todd receiving a motion or a letter from somebody? I can't appear for argument today. It's inconvenient to drive. That having been said, there are situations where it is appropriate. So I generally approach it on a case-by-case basis. I can honestly say I don't believe I've had a request for a family member to participate electronically. I have had a number of cases where the AIP was hospitalized and was capable of participating, but was not capable of traveling. And those we allowed to participate. I've also had doctors participate in some cases electronically. So basically, I look at it, and I think what happened, at least for me, with the pandemic, was the pandemic was the good cause. Okay, it was the good cause, but we got used to it, and we forgot that we should have good cause. So I look at the case, I look at who the witness is, okay? What is it they are expected to testify to? Are they somebody that's dispositive or ancillary? All right. The closer it gets to dispositive, the closer I am to they have to come in. All right. And then I want to know what the reason is. Again, if the reason is it's inconvenient, I'm sorry, court is inconvenient for everybody, without exception. okay? If the reason is I'm sick, if the reason is I am out of state, if the reason is, can't get there.
How about the reason is, I know there's an outstanding warrant for my arrest?
Fair question. Fair question, because I do a lot of support enforcement. And it is the defendants in the support enforcement who often ask not to have to appear. They might be arrested that day if they appear. I never permit them to appear electronically.
Well, we also have our most common participant remotely is our expert witnesses. And, it's hard to find good experts sometimes, and when they're busy people, asking them to come into court is not convenient, certainly, but I actually had Michelle oppose a request from an expert to appear remotely, which was fascinating because I knew when she opposed it, she knew something that she wanted me to know. So it's not always a slam dunk with regard to experts.
Yeah, I would say I would also consider whether there's an objection. And I have had objections, and I have required experts to testify. And more often than not, that goes back to the earlier question, was it dispositive? And that lawyer thought that witness's testimony was dispositive in the case. Now I'll share, there, and I cite this all the time, there's a decision by Sandra Schultz-Newman where she refers to the credibility witness as involving a two-part analysis. The first part is substantive credibility, and the second part is observational credibility. And it is far easier to do that when the person is live and in front of you than when they are on television.
All right. We're going to do a little law for a minute here, talk about how the law has changed. And there we have a lot of topics we're still going to come back to. But you've all heard about this, and you're all familiar that in 2023, the legislature changed the law regarding guardianship in Act 61, and now requires appointment of legal counsel in all cases. I mean, interestingly, when we started this project and when we started the grant funding, that was not in Pennsylvania law. It was discretionary with the judge. So this was a real innovation when we started in Dauphin County with court-appointed counsel in every case through a legal services organization. And as Rodia mentioned, yes, we need it in the cases with people under 60 as well, and now it's required by state law. It includes the initial hearing, also includes review hearing. Counsel is required, and was enacted, as you know, with bipartisan support and signed by Governor Shapiro. Somebody said yesterday, I think it was Senator Collette, that getting the entire legislature almost unanimously to pass this legislation in both houses, it's just not something that happens these days. It did happen with this legislation. So one of the elements, there are a couple of things in the law that are worth knowing. Counsel must certify that they met with the client before the hearing and file that certification with the court, I think 5 days before the hearing. So Mid-Penn does that, but you've heard these judges say not every court-appointed counsel over the years did that. Some people were meeting with someone in the hallway before the hearing. The legislature is on to that and said, no, that's not acceptable. You need to meet with your client, know your client, learn about your client, be prepared for the hearing. You can't be prepared if you meet them that morning in the court hallway, right? The legislature also specified counsel needs to be qualified by training and experience to handle guardianship cases, to be sensitive to people with diminished capacity, to know the rules of professional conduct as they relate to someone with diminished capacity, right? How do you advocate for someone if they do have diminished capacity? Probably everyone knows how to advocate, every lawyer knows how to advocate if they could say, well, my client doesn't even have diminished capacity, this case is wrong. But what if they have some diminution and you need to work with them to find out what they want, what their goals are for the representation? And importantly, the statute provides that the court-appointed counsel may not also be a guardian ad litem in the same case. So I wanted to talk a little bit about guardians ad litem and about that distinction.
Which is interesting because, again, in the children and youth world, the guardian ad litem that we have in a termination process can actually petition the court to be appointed legal counsel as long as the court makes findings on the record and finds that there's no conflict of interest between the two roles. But that's not something statutorily that can happen.
Right. Have any of you had a case where you were asked to appoint a separate guardian ad litem in a guardianship case since this project?
The answer to that question is mostly yes. I largely did it sua sponte. What happened was, the distinction between the two is an important distinction, because the lawyer is not necessarily advocating for the best interest of the client. The lawyer is advocating for what the client wants. And sometimes the overwhelming evidence is they do need a guardian, and that lawyer's standing there and said, no, I object, because my client doesn't want it. And we recently had a case, it was truly somebody under 60, so MidPen wasn't involved in it, where the woman was paranoid schizophrenic, and it was her family that was seeking to get the guardian. So I appointed a lawyer, and he did everything he was supposed to do, but he comes to me and he says, I am having two problems. What's that? First one, I'm a man and she doesn't like me, which in fairness, I get, okay? And the second thing was that she didn't want a guardian. She was absolutely adamant she didn't need a guardian. And to some, the interesting thing was when she was medicated, she understood. But when she wasn't medicated, which was the problem, she didn't understand and didn't want it. So in that case, we had a couple hearings, and I finally turned to the lawyers. I said, don't I need to appoint a guardian ad litem in this case? So I have somebody that can dig into this and tell me what in their impression is in the best interest. So in that case, I appointed both a lawyer and a guardian ad litem.
And I typically do so in high conflict cases when the family dynamics play in, where you have adult children who feel that maybe they were slighted sometime during their lifetime, so they have a different perspective than some of the other siblings. And mom or dad is put in the middle. And in order to take some of the pressure off mom and dad, I think it's important that we have a guardian ad litem appointed to work out those differences with the family members, to work through the family dynamics, so that the attorney counsel who is appointed can focus on their role as counsel. So that's something that I've done sua sponte, but it's also something that has happened upon the motion of counsel.
Yeah, I would agree. I've had the same experience. We don't do it a lot, appointing guardians ad litem, but it is in unique cases that present unique problems, or cases where even where the lawyer knows I've got to advocate against appointment of a guardian, or I've got to advocate to give power of attorney to the son who's the exploiter, right? Because that's what my client's insisting on. But there's a real problem here that the court needs to know about, and someone else needs to be a voice for the best interest of the person.
Now, the one thing is the guardian ad litem is not reimbursable, correct? So that's the one that's the one thing that the court has to be cognizant of, but it shouldn't affect your decision making. Where the money's coming from and who's paying should not play into that decision, but you're not going to find it happen very often from originating from, say, for instance, a court-appointed attorney that's got a contract with the county, and the county's going to have to cover the cost of the GAL. That's another reason why I love the legal services model, because they don't care.
This is the statutory section. You all know we now are appointing counsel in all the proceedings, including proceedings to modify or terminate or a review hearing or post guardianship proceedings. Rodia, any thoughts about the role of counsel in these that you could share with us?
Yeah, it gets back to my earlier comments. If you don't get to know the person, and that's how can you be a zealous advocate for the person? And that's why you have to get to know the person. You can't, this is just my own, this is the way I always practice. I got to know my clients to understand, because I'm representing them and I have to represent them zealously. And that's what, through our training, that's what our advocates do. And in these cases, they get to know the people. And yeah, there are going to be people who are, some folks are going to be do have diminished capacity, but that doesn't take away our responsibility to advocate for them in the best way under the rules of professional responsibility. So, and that's the mindset that the advocates have when they go into it. That's the mindset, because it's like any client that we're representing, we have to get to know them, and there are going to be differences, and as you can imagine, because people may have disabilities, other things that are going on, but in their lives. But yeah, I mean that's first and foremost. This is our client. We're going to advocate for them zealously.
So I thought we might talk a little bit about capacity evaluations in this context of we now have Act 61, we have an emphasis on alternatives to guardianship, we have all this great advocacy in the courtroom with the person represented, with the possibility of a guardian ad litem. How is that affecting your view about capacity evaluations, and how does the capacity evaluation itself relate to identifying less restrictive alternatives or limited guardianship that might work?
Well, currently, we have a form that is used for the expert report. And I know that Kendra's here today. She is chairing the Orphans Court Procedural Rules Committee. I know that we're looking at that form because nobody really likes the form. It doesn't really fit what we're trying to do, and it's not very conducive to exploration of those lesser restrictive alternatives because they're checking the boxes. But when looking at the capacity evaluations, it's up to the court and counsel to determine whether that person is really qualified to render an opinion. And the one thing I have seen through MidPen is challenges to the qualifications of the expert to render the opinion that they render. I mean, I haven't seen it as dramatically, but having someone's podiatrist fill out a form that says they don't have the requisite capacity is not going to pass muster. So I like the fact that, again, when you have an independent agency like MidPen Services, they're willing to push the envelope on the qualifications of that expert. I mean, the first time that I had a challenge and the petitioner, who is a regular petitioner, was required to voir dire their expert and to offer the person as an expert and then be subject to cross-examination by MidPen's attorney. We actually had one situation where I deemed the expert unqualified. Boom, it's over. The petition fails. So you have to take a really careful examination with the onset of, the use of testifying remotely. The one thing I really don't like is when the expert performs their examination remotely. Because as Judge Gavin had mentioned, having that expert in front of you, you have the ability to judge credibility. So we looked at them really, really restrictively.
I have to begin by saying I'm a trial judge, okay? I'm not much more than that. I listen to evidence, I make decisions based on the evidence that's presented to me. I look at the attorneys and I say, this is your case. You tell me how you want to prosecute this case and defend this case. I generally get the capacity evaluations in one of three ways. The first is that it's not uncommon that the lawyers will stipulate to their admission and they just get submitted to me in writing. It happens. And usually that's where the attorney for the AIP has looked at it and said, yeah, this is pretty accurate. The second, and this dovetails to our earlier discussion, I will get it through some type of electronic testimony. And then the third is the evaluator will actually appear in front of me and testify. I do sense what I will describe as a cottage industry sometimes in these things, and by that I mean we're always going to the same person who's coming in to tell us the same thing in the same way every single time. If I pick up on that, I get a little concerned, but I'm very interested at that point, one, what the cross-examination of that expert is going to be, and it can be on qualifications like Judge McNally said. It can be on the opinion itself. It could be on what they considered and what they didn't consider that they should have considered. Those are all just normal trial court things. And then the last part of it is, whether it's electronic in front of me or live in front of me, I am not afraid to ask questions. And I ask a lot of them, and I ask difficult questions, and I ask difficult questions on purpose. I want to see whether this person can defend the opinion they want me to rely upon to deprive a human being of their freedom. No more than that. So again, it's one of those kind of mixed feelings about them.
And I have the same experience that, there are some cases where counsel will stipulate to a written report coming in evidence when there really isn't a lot of controversy. They're in agreement with what the written report says. But almost any case that might involve a less restrictive alternative, that might involve some way of meeting the person's needs short of guardianship, that might involve a limited guardianship, we end up needing to have that expert testify. We need to be able to, the counsel needs to ask them questions, I need to ask them questions. We need to talk about what functionally does this person have the ability to do that we ought to preserve for this person. Do they have the ability to understand an election and vote in the election? They might, right? They might not have the ability to manage their 401k, and they might still have the ability to make a lot of personal decisions about where they want to go for worship, who they want to associate with, where they want to live. There are individual decisions that people can make even when they have some diminished capacity. And we have to have the expert be prepared so they can answer our questions about drawing those lines, or we're not going to have a success at the hearing. I mean, Rhodia, did you have any thoughts about that?
Well, one of the things that I think is important to note with all of these cases just is the intersection of not only the law and the health, but it could be education as well. Particularly if you're talking about a younger person who might be aging out, and did they, in school, did they have an IEP? Did they have, were they in, what kind of class were they in? And I think all of that, it goes to, or even someone who might be older now, what was, educationally, what happened? Where were they? What was their schooling like? So I think, again, it really gets, for me, and I think for all of us as we try to do, we get to know the person holistically. So that, and when you're talking about experts, bringing in experts, whether it's health or psychological or whatever it is, or even physical, medical doctors, whatever, I think you want to know, I want to know, in what capacity have they interacted, and do they know this person? Is it someone that they see just once a year, or is it something that they see when they see on an ongoing basis?
And that happens all too often, where you have the staff that is tending to the person on a daily basis, staff who's actually performing some of the tests, and then some doctor shows up and is going to testify based on information, and he's seen the patient 3 times in the last year. So that's something that drives me a little bit nuts.
You know, you guys are reminding me, just talking about how we think about alternatives to guardianship. I had a case recently that was really illuminating. It actually didn't arise in guardianship, it arose in a power of attorney, but just tell you quickly this story. I have an elderly gentleman, 96, very forceful and articulate. I met him, told me all 4 of his names, insisted on his dignity and insisted on respect. Okay, very interesting individual. He had 3 daughters, adults. For a while, he was living with one daughter, and she had agency under power of attorney. And from what I understood from the testimony in the case, her view was, he's incapacitated. He has dementia. I've taken him to the doctor. He's incapacitated. He can't do anything. He can't manage his bank accounts. He can't have a say over anything. He can't put the forks and knives in the right slots when he puts things in the drawers. He can't fold the sheets and put them in the right place in the cupboard. He can't do anything. And she wanted to deprive him of his right to make decisions over some of his finances and who should be his agent under power of attorney. He went to the other daughters, and he decided to live with one of the other daughters. And in that household, she and her husband were retired. They had time for him. They weren't annoyed by him. The husband really enjoyed having him around. He had been an electrician, the dad. They were working on the house, and the husband gave him things to do. They took a ride in the car every day. Dad didn't drive anymore, but his stepson or his son-in-law drove. They went to the diner. They met some people for breakfast. They went to church. He drove them around. They were buddies, and they spent all day together, and he didn't get into any trouble. And he didn't have to put the forks and knives in the right slots in their house. Somebody made it happen, and they didn't criticize him about that. And the accommodations that they were able to make for him, which he did need some accommodations, they just made them so graciously that it worked. And he wasn't angry, and he wasn't belligerent, and he wasn't bossy, and he was content to be part of this family because he was treated with respect and love and accommodated when he needed an accommodation. And that attitude made all the difference as to whether you saw this as a case where he can't manage anything and he needs someone to take over his affairs, or you saw this as a case where he can make some decisions about where he wants to live and what he wants to do with his morning and whether he wants to participate in this home renovation project and paint the walls or whatever he was doing. Like, he could make those decisions and he could exist because the environment adapted to him and supported him. And I just think, to me, that case was a real metaphor for how we need to think about alternatives to guardianship, because if someone's needs are being met and they can be met graciously and they can have a role and feel that they are respected and have decision-making authority and have a role in those decisions, we don't need to deprive them of all of their dignity and put a stranger in charge of their affairs if we can find the tools and the people who can help accommodate their needs.
And I think that the one thing that, in looking in that scenario, we all see those similar scenarios where you don't have to have the default of a plenary guardianship to begin with, let alone a plenary guardianship of the person and the estate. We've all seen many circumstances where someone's completely capable, with some of those lesser restrictive alternatives, supported decision-making, to handle their own personal affairs, but may be subject to scams. And so we've had many circumstances where people had no guardianship or a lesser restrictive alternative on the person, yet at the same time, even a limited guardianship with regard to specific things on the financing end. So you have to be creative.
If I may, so because we're talking about Mid-Penn, it just reminded me of this story. So again, I think the most important thing to remember is we're dealing with human beings, okay? Living, breathing human beings. whatever their circumstances may be. So I was saying to Rodia this morning, they are living, breathing human beings until they're not. So we had this one case, it was with MidPen, and the guardian comes in, and I say to the guardian, I said, how often do you see this guy? She goes, I got to tell you. She says, he's kind of ornery. He's troublesome. He's difficult. And I said, yeah, okay, fine. How often do you see him? She says, well, once a month if I can. I said, well, what does that mean? She says, well, I'll go there and he may be in a bad mood and I just can't see him. And I said, well, so how much time are you spending with him? She said, oh, maybe 10 minutes a month. Okay, that's 2 hours in a year. So I say to her, I said, let me ask you a question, ma'am. Did you give any consideration to the fact that the guy just doesn't like you? She says, no. Why wouldn't he like me? I don't know. So I turned to MidPen. I said, so what can you tell me? When did you get appointed to this case? I got appointed last week. Since last week, how many times have you seen him? I don't know, 3, 4 times. Each visit, how much time did you spend? No less than an hour, sometimes 2. So in the less than 7 days since the appointment, MidPen had seen this person more times than the assigned guardian had in the last 12 months. So I said, what can you say? She says, oh, Judge, you nailed it. He don't like her. He's a very engaging man if you give him the time, if you show him the respect that he deserves as a human being. And that's what MidPen did for him.
So we've talked about a lot of territory. I was going to move on a little bit to review hearings. Again, just talking about the law for a second, because we are getting CLEs for this. A required review hearing. The new statute requires that if the evidence demonstrates that the need for guardianship may change or the person's capacity may change, court's required to schedule a review hearing within the first year. That's new. A lot of us have been scheduling review hearings on a case-by-case, on an as-needed basis, but this is new, the required review hearing. I think that you'll find, and a lot of us have talked about this, there is an increase, we're all increasing how much we're scheduling review hearings, either upon request or sua sponte, or to find out what's going on when a guardian says in their report, well, I haven't visited in 6 months. Well, what's going on with that? How are you fulfilling your duties and making sure this person is okay if you're not seeing them? So we're all considering scheduling routine review hearings, and particularly in my court, where I have a lot of cases that are 15, 20, 25 years old, and I don't know those cases. We're bringing them back for review hearings so we can find out what's going on and what has changed, and do we have anyone who's regained capacity? So what do you think about, what can you tell us about review hearings?
Well, the one thing I think that's important for everybody to understand is when counsel for the incapacitated person asks for a review hearing, they don't carry the burden of proof. The burden of proof never leaves the petitioner. So that's one thing that I have seen MidPen request, and other counsel, private counsel has requested review hearings, and I have one pending where they have asked for an IME, the appointment of independent counsel to examine the incapacitated person to render an opinion. So that's aggressive, but I like it. I like it a lot. Question is, who pays for it?
It's funny you say that because I received one recently where they filed the petition and they asked for an IME. The petitioner did. And they put it in the scheduling order. Schedule this IME. I crossed that out. And I said, no, that doesn't happen until the person has a lawyer And the lawyer can come in and take a position on that subject. Okay? Because that's just as invasive as anything else if it's done involuntarily.
I think that's exactly right. In fact, I think the statute doesn't permit the petitioner to ask for the independent evaluation. Only the alleged incapacitated person, through their counsel, can ask for an independent evaluation. So sometimes review hearings come up because, and we've talked about this, we need to find out there are concerns about a guardian's reports or concerns about their compliance with fiduciary responsibilities. Either concerns are raised about the spending when we review the reports, concerns are raised about their visits, their ability to meet the person's needs, or they're just not filing their reports. And I'll say in that case, I certainly see a lot of families where, and I do think we need to be sensitive to this, where what's going on is caregiver overload, right? Anytime we have a guardianship because someone is sick, someone needs care and help, someone needs assistance, and some family members are involved in that person's care, usually, not always, but if we're lucky, we have family members involved in that care. So it may be that the family members in the case are actually having caregiver burnout or caregiver overload, and those guardianship reports are just something they cannot master. So I always tell my staff, we need to handle this with sensitivity. We need to be kind to the people. We do need the reports. We need them to understand why we need the reports, and we need them to work with us. But we need to be kind when we approach them and tell them we might need to schedule a review hearing or at least find out what's going on.
So are you suggesting that my threat of a bench warrant, if they didn't get it in by Monday, was a bit aggressive? But I did have that situation happen where we had, again, family dynamics involved, 3 adult daughters and mom, and we had a POA that allegedly was abused, and a guardian who neglected mom to the point where she had to be hospitalized. And, a red flag was that the guardian did file a timely report of the person, but not of the estate. And so that was one where I had gone a little bit up and beyond and required that the guardian provide counsel for the alleged incapacitated person, a weekly accounting of their expenses, and to file the report on or before, I gave them 30 days, or a bench warrant would be issued. That bench warrant would have been issued this past Monday, but the report was filed. The report was lacking, but it gave us something to work with. So the one thing that's really important that we stress is that GTS is really, really user-friendly and much easier for people to file them. Plus, they don't have to pay a filing fee when they come into the courthouse. So it's a big selling point, and those booklets are great to help people through the process.
In my experience, the notices come generally from one of 2 places. Either the Register of Wills lets me know something hasn't been filed, or in my county, we're extremely fortunate that we have a tremendous law clerk that is just dedicated to this stuff, and she looks at it all the time. I completely agree with Judge McNally that often it is the family members that just don't understand what they were supposed to do. So what I will do is I'll often just issue a rule to show cause that says, show cause why you didn't file this report, and if you file it by this date, you don't have to come into court. And almost all of the time they get it filed.
I had a good one with a family member who, honestly, she was filing all her reports and she was overly compliant, overly concerned to make sure that she documented every 50-cent transaction that occurred and calling us up to check whether her math was right and, all this stuff. And I had her come in, and she and her ex-husband had a son with intellectual disabilities. They were very harmonious. They were on the same team taking care of him. She had been appointed his guardian about 5 years before. And she was guardian of the estate, but she was also a rep payee for Social Security, and his only income was Social Security. And I said, Rosemary, do you need to be a guardian of the estate? She said, well, I don't know. Somebody told me I needed it. I said, have you ever used this order that you've had for 5 years? No, nobody's ever asked me for it. I said, I don't think you need to file these reports anymore. I think we can get rid of this guardianship of the estate. You can go forward as rep payee. You're clearly meeting his needs. You guys are clearly doing a great job. We don't need you to be coming to court on a rule to show cause on a guardianship hearing or whatever it was. It might have been that we called her in because she wrote, I don't know if I'm doing this right, or something. We were basically trying to help her, but we were able to end the guardianship of the estate, so she didn't need to file those reports anymore. Sometimes a review hearing can result in terminating a guardianship in one or both capacities, as we just talked about. Whether it's because capacity improved, or they have no assets and they don't need a guardianship of the estate anymore, and their only income is Social Security income. Maybe if they have a trust or a special needs trust, you might need a limited guardianship of the estate just to interact with the trustee, or no guardianship of the estate if you don't even need that, if that's where the assets are managed. Or where, we have relatives willing to act as healthcare representatives and there's no conflict among the relatives. And these cases are complicated. You do need to find out, well, is there no conflict among the relatives? Can they make decisions together? This is why we'll never be replaced by AI, because these decisions are, these cases are all very unique and all very different, and they do require a judge who's willing to listen to the people in front of him or her and find out what's really going on.
Many of you were here yesterday to hear Mary Catherine Scott talk about the guardianship, pro bono guardianship monitoring program that Dauphin County does. And I will tell you that I review those reports on a daily basis. They come in, and they many times will trigger review hearings for a variety of matters, but one of the most common reasons they will trigger a review is because we have guardians who are aging and are looking for successor guardians. So that is something, again, that we will trigger a review, will trigger the appointment of counsel, and quite frankly, that's one of those times where I wish we had a family engagement initiative to bring the family members in to relieve the persons who are fearful that they will pass away and there will be no guardian.
One more thing about review hearings. They can be scheduled sua sponte. I think all of us have said that the court can schedule a review hearing even without a petition requesting it. And we do, because we're looking at these reports, we're learning something about the case. Either the reports aren't getting filed, or we're learning that there's an issue. Two guardians aren't getting along. Somebody's not seeing the person. Whatever it might be, there's an issue we feel like we need to look into. One of the ways we can do that is schedule a review hearing without a petition. Or it can be requested by counsel, or it can be requested informally by some other interested party. Let's say there's a sibling who says, hey, that guardian is exploiting mom. You appointed the wrong person. They can request that a review hearing be scheduled. On our website in my county, we do have a one-page form to request a review hearing, or if someone came into the clerk's office, they can get a one-page form to request a review hearing. But if they were to write a letter, we would treat that as a request for a review hearing, and we don't require that a formal petition. You hire a lawyer and file a petition.
And a lot of times they can be triggered by GTS, because we are obligated as a court to review the reports, the annual reports of the guardianship of the person in the estate. And if an anomaly shows up, the person that reviews them, ultimately that falls upon the court, will schedule a review hearing. Now in Dauphin County, we have our reports being reviewed by court administration, but I know different counties have someone actually in the clerk of the orphans court office reviewing them. But every county does it differently, but many times GTS will kind of throw up that red flag and we'll schedule a review hearing to bring everybody in to figure it out.
Thank you to our wonderful panel. We really appreciate all of the work of the lawyers and the judges involved in this work.